Further hearing in the interchange appeal.
My Lords, I'm due to finish at 11:10.
Yes, Mr. Bailey.
I would like to conclude on broad acts and then emphasise a few points on the second issue. That's the evidence. On the issue of broad acts, the issue is really quite narrow, but nonetheless important. And from yesterday's exchange, there are two issues I wish to address. First, the burden of proof, and second, how to calculate the extent of pass-on. So, burden of proof on pass-on and extent of pass-on. Begin with burden of proof. Can we go to MasterCard's written case? That's at Core Bundle 1, MS 4954, 4954. Because I'd like to begin with the common ground between the parties on this appeal, which I think is quite important. And the relevant paragraphs are paragraphs 107 to 110. You'll see at 107, the fourth issue is about, according to MasterCard, assessing quantum and mitigated loss. At 108...
Yeah, and it's also said to be a matter of general importance to the law of damages in tort.
Yes.
Not confined to competition
law. And then 109C, MasterCard accepts there is a need to prove a sufficiently close causal link. And then at paragraph 110, it refers to EU law, and 1010B gives the position, as I stated yesterday, national laws may prevent a claimant being unjustly enriched as a result of overcompensation where all or part of an unlawful charge has been passed on by a direct purchaser. Payment of the full amount of the overcharge to the direct purchaser would give rise to unjust enrichment. Whether or not the unlawful charge has been passed on is a question of fact. The burden of proving which lies on the defendant which asserts it. So throughout the whole of the litigation before the tribunal, before the Court of Appeal, MasterCard have accepted that the legal burden is on it.
Well, that's as maybe.
It is a maybe, yes.
I mean, it may be right, but...
Yes, so I have to emphasise that this has been the common position. They refer to the San Giorgio case. Can we go to the San Giorgio case at Authorities Volume 7?
Well, I mean, if you haven't got much time,
I know.
I think you can probably take it. We probably all know San Giorgio backwards.
If you want to give us a reference to look at, I don't think we need to...
Paragraphs 13 to 14.
13 and 14.
MS 3050. Bar paragraph 30 of Crean, the Court of Appeal is the highest authority that the burden lies on the defendants in competition cases. So bar the analogy with paragraph 30 of Courage and Crean. But as I said yesterday, Parliament has imposed the burden on defendants.
Yes, but I mean, as I said yesterday, that's beside the point. This is a common law claim for damages, as I understand it. It's not a statutory claim, and the right to damages is governed, as I understand it, by domestic law, subject to the usual requirements of direct effect.
Yes. But it's a breach of statutory duty claim, so it's a breach of statutory duty.
But it's not governed by the Competition Act. I'm sorry, the provision you were talking about yesterday that imposed a statutory burden of proof, I thought you had told us that that didn't apply to the present claim.
No, it doesn't. But all I'm saying is that in competition cases, the Act adopts the damages directive, and the burden of proof is on the defendants in all 28 member states. In all 28 member states, the burden of proving pass-on is on the defendant.
So it's a claim governed by the directive?
No, it's not. But if one is looking at whether it is unjust on the defendant, the EU has said it's not. The burden of proof is on the the defendant. It's not unjust to impose a legal burden of proof on the defendant. And that's the same across the whole of the 28 member states, including now for the Competition Act. And in my respectful submission, it would be remarkable if the onus was on the claimant and it ignored the policy behind the Competition Act, which we is in tab 1, authority 1, and the damages directive. And the reason is the damages directive has implemented San Giorgio, the principle in San Giorgio, to competition cases. That is why paragraph 30 of Courage and Crean is so important. And the reason it is important, this remains a claim for breach of 101, and is subject to EU conditions and the principle of effectiveness. And that is why San Giorgio is so important. I should also add, if it goes back to 107, MasterCard defined this as mitigation. We haven't had time to look into the role of mitigation, but clearly the burden of proof in mitigation is on the defendant.
Well, the burden of mitigation usually arises through a plea that the claimant has failed to mitigate his loss.
Yes.
And obviously the burden is then on the defendant to make that good.
Because the defendant has asserted it. And he who asserts, or she who asserts, must prove. And that is the philosophy behind the passing on defence.
I mean, there's also a principle of mitigation of actually mitigated loss. There must be some authority as to who has the burden of proof in relation to that. Can you help us with that?
Well, we've got a House of Lords I'm not sure we've got copies. Mr. Turner has got copies of various authorities on mitigation, which we can hand up. Right. The authority referred to by McGregor is the House of Lords in Garnack, G-A-R-N-A-C, and that's 1968 appeal cases 1130, 1968 appeal cases 1130, page 1140. So it's not for the claimant to raise the issue of mitigation and then disprove it. It's for the defendant, even that it's wrapped up with the principle of compensation.
So are you telling us, as a matter of English law, where there is a plea of actually mitigated loss, there is authority that says the burden is on the defendant
Correct.
to raise that?
Yes.
That's what you're saying. All right.
Mr. Turner will refer to a case that has been provided. I should add that whilst the legal burden of proof is on the defendant to prove pass on in our submission, there remains a considerable evidential burden on the claimant. A considerable evidential burden on the claimant. In the Sainsbury's case, if one remembers, Sainsbury's disclosed management accounts, budgets, pricing strategy, and oral evidence was given by its CEO and CFO, and this was subject to considerable scrutiny by MasterCard's forensic accountant and economist. So whilst the legal burden is on the defendant, he who asserts must prove, and that is consistent with the law of mitigation, there remains a considerable evidential burden on the claimant. When the defendant does raise the issue of pass on, it is at some considerable cost, often to the claimant. And that one should not forget the high evidential burden on a claimant in a pass on case.
What causes the evidential burden to fall on the claimant when the legal burden
Because the claimant has access to, obviously, its own internal accounts, and as one said yesterday, it will be in a better position to say whether it charged higher prices because of an overcharge. Therefore, if it remains silent, the judge will take that silence as may accept the evidence of the defendant as probative of pass on.
But the defendant won't have any evidence other than the documents and the oral evidence of the retailers. So are you in fact saying that there is simply a burden on the defendant to raise the issue, whereupon the evidential burden falls on the claimant? Or are you saying something else?
It's a simple proposition. The pass-on defence is a defence because one is saying you haven't suffered any loss because you've passed it on in the form of higher prices. That is a legal burden on the defendant because of the principle of effectiveness, Article 101, but there remains an evidential burden on the claimant to adduce evidence which is relevant to whether there has been pass-on or not.
But what triggers the evidential burden?
The assertion by the defendant.
That's what I was wondering. So really the legal burden is simply, on that approach, an obligation to assert.
It may not be that the pass-on defence is relevant because it is quite a costly exercise. So if one imposes a burden on the claimant from the start, one is really raising the cost of litigation in this sort of action because the claimant then is going to have to disprove a negative, and that is why the CJ in San Giorgio said it was contrary to the principle of effective protection. But the cost to the claimant is going to be increased if you put the legal burden of proof of pass-on the claimant.
Well, one of the things I was looking at this morning was the background to the directive, which is very interesting.
Damages directive.
Yes, and in particular to what it says about burden of proof. And it appears from that there was a diversity of approaches in different member states, as you might imagine,
yes,
being governed by their national laws.
Yes.
And in France, in particular, there was a presumption of pass-on, so that the claimant had to rebut the presumption by leading evidence to demonstrate there had not been a pass-on, or alternatively, that it had suffered a diminution in sales or profits because of the effect of the pass-on its volume of sales.
Yes.
So it's quite a dramatic example.
It is, and can I just put, that is why these cases went to the CJU. That's why San Giorgio went to the CJU, because essentially there was a presumption that you'd passed the tax on. And the question was, is that national law compatible with EU law? The answer was no, because of the principle of effective protection and the enforcement of EU law. And but this remains a cause of action based on Article 101. And all the EU principles of effective protection are still in play. And paragraph 30 of Courage and Korean say they are. And in my respectful submission, the balance is the legal burden is on the defendant, as they've maintained throughout and accepted throughout, but there remains a high evidential burden on the claimant if, and this is the big if the defendant asserts it. Because the defendant may not assert pass-on.
And I don't think we've looked at the damages directive. What's the date of it and where do we find it in the bundles? I'm not asking to look it up, I just want...
It's not, we have copies of the damages directive.
All right, so it's not in the bundles. What's its date?
It's... Have you got the...
All right, if you don't, let's not take up time on
It's...
look it up.
2014.
All right, thank you.
2014. So it's referred to by the Court of Appeal at paragraph 326. 326.
Thank you.
And the damages directive, obviously my lord has seen it because looking at the preambles, but it is a fairly comprehensive code as to how you treat pass-on both for indirect purchases and for direct purchases. And the court will have seen that the philosophy is, and this is enshrined in the Competition Act, the legal burden is on the defendant and the defendant must prove the extent. Can I turn to the extent of pass-on? because in my submission, this is the real issue between the parties. And can I just show the court the different arguments on the extent of pass-on. Go first to the Court of Appeal at paragraph 331, that's 5275. 5275. So I just want to set out the respective arguments and then explain why the Court of Appeal's approach is to be preferred. We saw this yesterday, paragraph 331 at the end, but I do rely on 332 So clearly the judge has to make an assessment of the extent of pass-on. The judge may have to estimate pass-on. We don't deny that. But, and this is the big but, the issue remains within the confines of proving a sufficiently close causal link. And I'll come on to this in a moment. That is, we say at 331, 332, what the correct analysis is. If we can go to MasterCard's case...
Forgive me, 332 addresses questions of causation.
And we say...
And the case now put, I think, Mr. Hoskins made this clear, is simply in relation to quantification.
Absolutely. And that is the key distinction between the two of us. And I'll come on to this, but that is, does it remain a question of causation, or does it become a question of quantum? That is the real key difference between us. So can I then just go to MasterCard's written and then orally, and then explain why?
I'm sorry, I would say I'm a little bit unsure what the importance of that distinction is. I thought in 332, the causation is relevant to quantum, because if the overcharge has been received, and one can see that because the overcharge has been received, there's been a pass-on to customers, the quantum goes down. So, yes. So why isn't causation built into the quantum question?
Well, they overlap, but my essential point is you can't ignore a direct causal link for the whole of the overcharge. What Mr. Hoskins wants to do is have a direct causal link for part, and then the rest becomes an issue of valuation. And this is an important distinction. If I can just tease this out, because if one goes to the MasterCard's written case, we see this difference between causation and valuation in stark terms. It's paragraph 119 to 121.
Sorry, paragraph?
119 to 121. This is MS page 4958. 4958. So what MasterCard's case is that this is the second, penultimate sentence of 120. It is sufficient that it established on the probabilities that it has suffered some loss. Having done that, then it becomes a question of evaluation. And at 121, a similar analysis applies in relation to mitigation. So they are applying the quantum analysis to mitigation. And can I just emphasize how...
The problem you have is that it doesn't follow from the fact that a myth was charged that you suffered any loss at all. So you have to prove you suffered some loss.
Well, the loss is the overcharge, and that is how the Competition Act...
This is the point Lord Hodge made yesterday. The myth element of the MSC isn't per se loss.
Well, it is an overcharge.
Yes.
Well, so what?
Well,
But But you can only claim, if you are the victim of a wrong, you can only claim reasonable loss, and that's what the principle of mitigation is about, you can only claim for the losses which you have suffered. Now, if in reality, regardless of who's proving it, if in reality you have passed it on, have you suffered loss at all?
Don't deny. I mean, it is clearly wrapped up. So is the law of mitigation. Law of mitigation, if one was to look at this in the textbooks, the law of mitigation is wrapped up with causation, which is wrapped up with loss, compensation. They're all linked. There's no doubt about that. And as we say in our written case, pass on is concerned with whether you've suffered any loss. But the question is, who bears the burden of proving that? And is pass on a question of causation, or is it a question of evaluation? And what MasterCard do in these paragraphs, they start with the question of causation, because they accept they've got to prove some pass on, and then they say, having proved some pass on, the rest is a question of quantum.
There is a risk of going round in circles here, but you'll see the problem that we have.
Can I finish?
Let me put it this way: you can't simply sue for the amount of the MIF and say, this MIF was unlawfully charged, therefore we're due to have it repaid. Your claim is one for damages, and so presumably your claim runs along the lines, we suffered a loss of profits because of the overcharging of the MIF. It diminished our profits by X from what they would have been if there'd been no breach of Article 81. And then, presumably, Mr. Hoskins' clients can plead that, in fact, your loss of profits wasn't as great or indeed anything at all because you passed on the charge to your customers.
That is going beyond what Mr. Hoskins is...
Well, it may be.
Yeah, but I'm just making the point.
We're being asked to give an important ruling, which we're told is of the law of damages, and if the parties have approached it in the wrong way, we're not bound to follow them. I obviously appreciate that, but when the parties come to court with a common position and we have to meet a case at paragraph 120, if it goes way beyond that and the legal burden of proof is now on the claimant, we would have dealt with that in far more detail in a written case and orally rather than with 10 minutes to go.
I fully accept that this has been sprung on you, and it may well be, once you've heard from the other side, that you will want to put in written submissions. But if we are being asked to make a ruling which affects the law of tort widely, I think we really have to try to get it right.
Well, I'm grateful, but I understand the power from my lords, but it is. I think that my lords understand where I'm coming from.
Yes.
So, with that, then I think I will take up that invitation. Could I just make a couple of points on evidence, if I can move away, because there are just a couple of points to emphasise on the issue relating to evidence. Could I go to Core Bundle 2 at paragraph 81, that's 5225. So paragraph 81.
Sorry,
5225. And I will do this in 5 minutes, basically. There the Court of Appeal says at 81, although the standard of proof is a matter of English law, the nature of the evidence which will satisfy that standard must be informed by EU law. And what I would like to address is how the nature of the evidence is informed by EU law, and there are at least two routes whereby courts are informed by EU law. There are two routes that we have seen. The first route may be a general evidential requirement as a matter of EU law. Because EU law does actually go into evidence sometimes. So the first route, it may be a general evidential requirement as a matter of EU law. The second route is Section 60 of the Competition Act. Section 60 in brackets 2 refers to corresponding question. Section 63 refers to any relevant decision or statement of the Commission. So there are two routes. Can I explain the first route and how it applies to the need for cogent evidence? So very quickly, can we go to the Ituras case at tab 20, which is bundle 2. This is the case cited by Visa at 561. So this is the first route.
Sorry, you're going to have to help me. It's
So
tab,
it's
tab
MS page 561. It's volume 2 of the authorities. 561. The relevant paragraphs are 29 to 33.
It's tab 18.
Oh, I beg your
18,
pardon,
it's
tab
18, not 20.
yes.
That's-
Tab 18. 561. And the important point here is that there can be requirements as to evidence as a matter of EU law. So if one looks at the first line of paragraph 32, so this is tab 18 of, according to settled case law, in the absence of EU rules on the matter, it is for the national legal order. So you do look to see whether there are EU rules on the evidential matter. And paragraph 33, the last couple of lines, says that if there are EU requirements on evidence, they form an integral part of the EU law which the national court is required to apply. So it's not the case that it's a free-for-all for the procedural autonomy of the member states. So if I can then just give the references for the need for convincing evidence, we have seen these, but since we're in volume 2, if we just go to tab 19, the Glaxo case, at MS 630, that's paragraph 235, 630, 235. A person who relies on Article 1013 must demonstrate that those conditions are satisfied by means of convincing arguments, convincing evidence. This is a requirement as to the interpretation of Article 101, particularly Article 1013. It is a requirement. It is repeated at paragraph 248, that's MS 633, and it is repeated actually in the MasterCard decision, as we've seen, which is at tab 24, at MS 959. So again, generally convincing evidence is required, but in particular with the MIFs, the General Court in MasterCard applied Glaxo at paragraph 196, 959.
But, I mean, this is all evidence in relation to the conditions under Article 101(3).
Correct.
They're not discussing about quantum of loss at this point.
No. But this is the evidence. I'm on essentially the second issue now.
Yeah.
I've left pass on.
Oh, I'm so sorry.
You've gone to ground 2.
Yeah,
Forgive me.
I'm sorry.
Yes.
I'm sorry.
Yes.
But I don't want to, as it were, open up another manhole in front of you. But one view might be that when the court is talking about the necessity for convincing evidence, that's the EU equivalent, effectively, of an English rule as to standard of proof.
Yes.
It's very similar to the French standard of a conviction intime, for example. And it may be that when you are looking at Section 60 of the Competition Act, I mean, if that is the rule about standard of proof that would be applied by the EU institutions, then does Section 60 not require us to apply that standard domestically?
Yes.
In which case you forget about balance of probabilities. That's not the standard.
My submission is that because this is a requirement, it would apply irrespective of domestic balance of probabilities. But the icing on the cake, as far as in my submission, is that it is consistent with the civil standard. Because as the Court of Appeal said at paragraph 79, the civil standard does in certain circumstances allow for convincing or cogent evidence. And if I could just refer to the last authority, and then I will finish, because this authority is consistent with what the Court of Appeal said.
Yeah, your case essentially is that there isn't a conflict between the domestic law and the EU law in requiring convincing evidence in this context.
Right, and maybe I don't have to go to it, but if I
But the
give
authority
the
will
court
use-
the reference, it is the Tartsinis case, which is volume 7, tab 54. It is a rectification case. So maybe if we just, and then there can.
Well, I might say that balance of probabilities is less demanding. And that, I mean, somebody can win on the balance of probabilities without the court finding evidence convincing. It may just be less unconvincing than the other side's evidence.
Well, all I was going to submit that in rectification, and the analysis is by Mr. Justice Leggett, as he then was, recognises that in rectification cases where there is a contract, the claimant would need to adduce cogent and convincing evidence to displace the presumption that the contract faithfully reflects the party's intentions.
Could I have the MS number for
Yes,
the
of course.
passage, please?
It's MS 2910. So it's the Tartsinis case, rectification, Mr. Justice Leggett, volume 7, tab 54, paragraphs 82 to 86, and it's MS 2910. And the need for cogent evidence to rebut the presumption is, he says, consistent with the civil standard.
And I hear what you say, but one never sees the expression of balance of probabilities in the EU decisions, does one?
There was a debate in the Court of Appeal and for the proof of breach of Article 101, and everyone came down to the fact that you had to prove that it was likely. So the balance of proving a breach of the prohibition is you've got to produce evidence to show that it is likely there was a breach.
Anyway, if there is any difference, the implication of Section 60 is that domestic courts should apply the EU principles.
If there is a heightened standard, so be it. But in my submission, there is not, because the civil standard already allows for differing evidential requirements depending on the fact that needs to be proved on the balance of probabilities.
As I understand it in a nutshell, what you're saying is that once you've established Article 101 breach, once you've established a restriction on competition, you are in the EU equivalent of it, there at least being a wildcat, maybe not a lion, in Regent's Park. And there is a greater burden persuading you that it isn't just a dog.
Right.
Yes.
That in a nutshell is it.
Yes, thank you.
I know that Mr. Turner wanted to refer to a case in response to Ms. Rose. He may refer to mitigation cases, but since we may be allowed to make written submissions on the burden of proof, which is clearly very important.
Yeah.
Those are my submissions unless I can be further assisted.
Yes, thank you very much, Mr. Brealey. Mr. Turner?
We have a distinct position from Sainsbury's on all four of the issues, and in particular, you will have seen that from our written case. We have a distinct and different approach on fair share and on pass-on. In view of the way that the argument has developed recently, we wonder whether we might have, say, 10 minutes simply to state our case very briefly on that point, to draw one authority to the court's attention, which has been notified to my friends, so that it can be debated as necessary. And any time that I take up will be taken off my time for the cross-appeal this afternoon.
Oh, very well.
If that's convenient
Yes,
to the court.
yes.
Very grateful. So the first issue is broad acts and the question of the burden, which is something that, as the court is aware, has arisen yesterday, essentially. English law applies on this until, in the United Kingdom, I believe March 2017, when European law in the form of the Damages Directive is implemented in national law in the United Kingdom too. That is referred to in the Court of Appeal's judgment at paragraph 331, and you do have a copy of the provision tucked away in Authorities Bundle 1 at page 24. If you want to look at that very briefly now, see Lord Hodge is opening it. It's the last page in tab 1. You will see a schedule, and the heading is passing on. And if you look at paragraph 11.2, you see that's the provision which has been made in our domestic law as of that date. But, my lords, until then, it is perfectly true that English law applies. It has been common ground that the defendant bears the burden of showing that there's an identifiable increase in the claimant's selling prices owing to its overcharge. The way in practice, to answer the questions that were raised this morning, this is typically arises as follows. On the pleadings, the claimant alleges that they have suffered a loss of profit owing to the tort, resulting in the overcharge. And it is said, this is the measure of our loss and damage. The defendant, in response, pleads that the loss was passed on by the claimant. Issue is therefore joined on the pleadings. The claimant must then produce evidence in the form of documents and the witnesses one would expect them to be able to produce. On either side, we say that the Court of Appeal correctly appreciated the broad acts applies if it is the principle that neither party should be subject to an unreasonable degree of precision in their task. In this case, a case such as we have before us today, it can be a complicated task, particularly in the case of a business such as a supermarket chain, where one's trying to ascertain whether there was an identifiable increase in price because of this factor. The question then of burden arises, is it essentially the position that the defendant has to establish that it is more likely than not that the claimant's selling prices went up because of this overcharge? Or on the other hand, does the claimant need to establish that it's more likely than not that its prices didn't increase as a result of the overcharge?
And presumably, I was thinking sometimes there's then an issue about the knock-on effect on sales.
Yes.
That I wonder if that arises in a situation where everybody is paying the MIF, whether you're Asda or Tesco or Sainsbury's.
It may, as a matter of fact, my lord, that is also a point which the Court of Appeal records that I drew to their attention. It's in the judgment too. That's at paragraph 334. Now, in the short time available, I found one case which is helpful, in part because it goes to points that have been raised at the early part of the hearing about whether in this sort of situation one accords any tenderness to a claimant, which is the victim of the behaviour, and also to Lord Sale's point today, and adumbrated yesterday, about the situation where there's been actual mitigation of loss and how one approaches it. The case is Thai Airways, a decision of Mr. Justice Leggett, as he then was, in 2015. I don't know if my friends have printed off their own copies yet. No, copies around.
Thank you.
I don't need it. I don't know if the court is at all familiar with this, this authority. From the head note, one sees the factual situation under letter E, that a claimant airline, Thai, enters into 3 contracts with a defendant company, Koito, for the supply of economy class seats for 3 groups of aircraft. Some seats are delivered late, others not delivered at all. As a result of the delivery issues, the claimant finds itself with fewer aircraft than expected, being prevented from using 5 new aircraft, which it had bought from Airbus for around 1.5 years, and it had restricted use only of another aircraft. And then in 2010, the claimant decides to lease 3 aircraft from another party, Jet, for 3 years at a certain cost. If you drop down between letters G and H, you'll see that the questions remained, the questions in that case, go to H, as to whether Koito, the defendant, had any burden of proof in respect of proving benefit, and if so, whether the defendant had discharged that burden, and lastly, what were the estimates of Thai's net loss of profits, and so forth. There are 2 relevant parts of the judgment. The first is less relevant, but I'll show you it straight away. It's paragraph 38 on page 686, where Mr. Justice Leggett is looking at the quality or the stringency of the duty the duty to mitigate lying on a claimant. And it is in that regard that he first mentions, that is paragraph 38 at letter J, the standard of reasonableness is applied with some tenderness towards the claimant, having regard to the fact that the claimant's predicament has been caused by the defendant's wrongdoing. And then at the bottom of the page, the claimant's not expected to take steps which would involve unreasonable expense, risk, or inconvenience. And over the page, in addition, the burden of proof on that sort of scenario is on the defendant to show there was a course of action which it was reasonable to expect the claimant to adopt that would have avoided all or an identifiable part of the claimant's loss. Then we come to the perhaps more relevant part for present purposes, which is page 699, where there is a specific heading, the burden of proof, at letter G, just above paragraph 83. And you see from just above letter J that there was Mr. Morpus, the claimant's advocate, submits that in the circumstances in that case, the burden was on Koito, that's the defendant, to prove that a certain mitigating act in leasing the aircraft, the actual mitigation, not only avoided the entire loss of profits, which Thai would otherwise have suffered, but generated additional profits, which would offset in whole or in part the cost of the lease. And the judge stands back and comments at 84. The reason why the burden may matter in this case is that it was common ground that attempting to estimate with any precision what Thai's financial position would have been if Koito had performed its contractual obligations, to compare this with Thai's actual financial position would be an extremely complicated task. Furthermore, it's a task which neither party tried to undertake. The reason it's so complicated is that a sophisticated commercial airline like Thai manages its entire fleet of aircraft in a way which is constantly adjusted to maximize efficiency and so on. So immediately there's a broad parallel with the supermarket, with a very, very complicated sort of business. Then without going into the elaboration, if you go to 85 at letter D, given the extreme difficulty of the exercise, if Thai was required to prove the amount by which it was worse off financially as a result of the defendant's breach of contract, despite the mitigating action, it might be unable to do so. I accept the claimant's contention it would be unjust if such difficulty of proving the overall net financial position were to prevent it from recovering expenditure it has reasonably incurred in seeking to avoid or reduce the damaging consequences of the wrongdoing. 86, where a claimant's incurred expenditure in the expectation that the defendant will perform the contract, I pause there, the analogy, although we're moving from contract to tort, is a comparison with the claimant increasing its prices owing to the overcharge which it has been made subject to. Such expenditure is recoverable as damages unless the defendant proves that the claimant would not have recouped its expenditure if the contract had been performed. 3 lines down. In this regard, the English courts have adopted the approach stated by Chief Justice Learned Hand in the American case. It's often very hard to learn what the value of the performance would have been, and it's a common expedient and a just one in such situations to put the peril of the answer on the party who by his wrong has made the issue relevant to the rights of the other. In my view, the same expedient must in principle apply where the claimant has reasonably incurred expenditure as a result of the defendant's breach of contract to avoid loss which the breach would otherwise have caused. 87. McGregor states that where it appears that steps have been taken by the claimant to avoid loss which had to be taken into account in assessing the damages, the onus is on the defendant to prove that, and also how far loss has thereby been avoided. As authority for this, McGregor cites the World Beauty case as decision of the Court of Appeal. In that case, damage caused through the fault of the defendants to the plaintiff's vessels required the vessel to be withdrawn from service to undergo repairs. To mitigate their loss, the plaintiffs charter another vessel to perform the remaining period of the charter. The vessel was already fixed for further employment when the charter ended. When the repairs were completed, there was still 3 months of the charter left. But because another vessel had been substituted, that vessel was free for alternative use. The owners were able to bring forward the next fixture, so it started and ended 3 months earlier. And then the final paragraph, 88. In assessing damages, the Court of Appeal held it was necessary to take into account the gains as well as the losses resulting from the steps taken by the plaintiff in mitigation. This was straightforward application of British Westinghouse. The difficulty arose in calculating the benefit to the plaintiffs of bringing forward the vessel's next charter. Lord Denning approached this question on the basis that it is for the defendant to prove the value of the advancement. It is he who prays it in aid in mitigation of damage. He must prove, therefore, the value of it. Fenton Atkinson, Lord Justice Fenton Atkinson agrees with that approach. So, my Lord, it's very necessary, very brief and telescoped at this point, but this is merely to demonstrate that in a position that has a situation that has some analogies with the present case, in the law of actual mitigation of loss, a burden is seen to be imposed on the defendant for the reasons stated there as a matter of English common law. So, my Lord, I say nothing further about that. I wonder if I may, additionally, because of the argument yesterday, make very brief points on fair share so that our position is clear. It's relevant to us because MasterCard, our opponent, associates itself with this ground of appeal. You have our point that it shouldn't be permitted to do that. Mr. Brearley took you yesterday to paragraph 92 of the Court of Appeal recording their position. There is also paragraph 259 in the Court of Appeal's judgment. Nonetheless, very briefly, we see Article 1013 as working in this way, and I draw to the Court's attention only those points that are necessary for answering the questions that arise in this case. First point is this: the first of the 4 conditions of 1013, that is the locus where the initial balancing exercise takes place. It is at that stage that you look to see whether there are appreciable objective advantages, first point, which arise of such a character to compensate for the disadvantage for competition, second issue. And that this is the case, and that it arises in the first conditions framework, is perfectly unambiguous from the European case law. And the 2 references are those, one of which was directly referred to by the Court of Appeal, in the MasterCard Court of Justice judgment itself, paragraphs 237 and 252, which the Court may wish to briefly have open in front of you. That was at tab 25, page 1079 and 1080. Essentially, in both of those paragraphs, the Court of Justice is perfectly clear in each case that it is referring to the first condition. Yeah. And it says what that first condition involves. From that, the questions posed by the court yesterday to my friend Mr. Brearley arise. What is meant by appreciable objective advantages, and what is meant by the term compensate for the disadvantages? Compensate whom, as the court put it? The meaning of appreciable objective advantages was clarified in the original classic case from 1966, Constant and Grundig itself, which is in the same bundle at tab 17, and the relevant passage is at page 478. Of the electronic numbering, I was looking at the European Court report numbering, I should say 532. I do apologise. Halfway down, in that old case, which has been oft cited and endorsed, they say in the second full paragraph, the existence of an improvement in production or distribution, this is the first condition material, which is required for a grant of exemption, should be judged in the light of the spirit of the treaty article. The improvement should not be identified with all advantages which the partners, the parties, gain from the agreement in their production or distribution activity. Advantages, they're generally indisputable and will show the agreement in all its elements as indispensable to the improvement as thus understood, such as subjective method, this is why objective and subjective seem to have come in, which makes the content of the notion of improvement dependent on the particularities of the contractual relations in question, wouldn't conform to the aims of the article. The very fact that the treaty provides the limitation of competition should be indispensable to the improvement in question clearly indicates the importance which the latter should have. The improvement should in particular present noticeable objective advantages, objective, I should emphasise, compared to the subjective that they have referred to earlier, such as to compensate for the inconveniences resulting therefrom on the level of competition. So what the phrase objective advantages means in the first condition is that you do not take into account at that point of the advantages that the parties to the agreements themselves derive. Then the question of, the second question posed by the court yesterday, whose interests does one consult in this balancing exercise, arises. For a case such as ours, forget the general picture, it is directly and clearly answered again in the same paragraphs of the European Court judgment in MasterCard at the end of this bundle, 237 and 240 to 241 on pages 1079 and 1080. Those paragraphs say that when you are doing this balancing exercise at the first stage, you look to the interests of the cardholders as well as the merchants in the aggregate, and you engage in the weighing exercise. But at paragraph 242 of this key judgment, the court says that at this first point, there must still be some advantages to the group which has suffered the harm, namely the merchants, if the analysis is to continue, move to the second stage of the condition. In the instant case, as 243, paragraph 243 says, there were no advantages which had been shown by MasterCard to accrue to the merchants. In the facts of that litigation. And in those circumstances, it became unnecessary to take the analysis any further, in particular by examining advantages to cardholder. And simply speaking, to draw this to a conclusion, our point is that none of that touches the second condition in Article 1013, which requires a further exercise, now focusing on the disadvantaged group specifically, namely the merchants. They must be left no worse off, paragraph 85 of the guidelines. And paragraph 247, this is why we have said in our written case, when you come to it further down that page, simply matches what was said by the Court of First Instance, the General Court, in its judgment. If you go back to page 965, at paragraph 236, it's a more condensed way of saying what the other court had already said, namely, in the light of the foregoing considerations, it must be concluded the applicants haven't established that the Commission's reasoning on the first condition was unlawful. Since the conditions set out in that article must be met if it's to apply, the second part of the plea must be rejected, and there is no need to examine the objections concerning other aspects of the analysis pursuant to that article. So we see it as simply saying that that is the position, and that is how we understand the meaning of these contested paragraphs in the judgment.
So we never got to condition 2.
That is right. We see that as tolerably clear.
And so is it under the second condition that there has to be the equivalent benefit to the group of consumers that has actually suffered the detriment here, the merchants, so as to at least leave them in as good a position as they would have been but for the cartel arrangement?
Yes.
Is that the way it works?
Yes, precisely that.
Okay.
And
that's, I think, in line with the guidelines. I mean, the guidelines, when it specifically addresses the second condition, says that.
It does do that, yes. The two relevant paragraphs of the guidelines are 43 and 85. In paragraph 85, I believe the expression that is used is that the net result must be at least neutral from the point of view of the disadvantaged group, or words to that effect. And that is how we see this working. So that is the only clarification that I need to give on that, following the argument that's taken place. I don't know if you'll give me a moment on the legal certainty point, which Miss Rose raised, and I did not have time to deal with in my submissions, which would also take another two minutes. But otherwise, I can leave time in the court's hands.
Yes, I think we're happy to hear you for a couple of minutes on that.
That is all it will take. The legal certainty point is a point that was raised by Miss Rose in relation to the evidential burden ground 2. In her written case, she argued that the requirement for factual evidence to establish the case for exemption, and I quote, is inconsistent with the object and purpose of the relevant legislation. And her argument was that the treaty prohibition against restrictive agreements bites from the date that the agreement's actually made, and therefore, before empirical real-world evidence, as she puts it, of the type demanded by the Court of Appeal can be available. And it may be that this was at the back of the minds of the court yesterday, but that is her position. And in those circumstances, it was suggested that the compatibility of an agreement with competition law has to be decided once and for all at the outset on the basis of the material which is available at the time, and that the legality of the agreement can't subsequently change because different evidence later comes to light. In oral argument, this was developed as an expression of the principle of legal certainty. That's day 2, page 98. And Miss Rose said that at the time of making the agreement, the parties are likely only to be able to make estimates or projections based on economic methodologies. And I have two short points in response, or rather three, because there is an authority. First, at the time of making an agreement, the parties won't be basing their assessment on mere economic methodologies. At that first stage, there will be some factual data available. The economic methodologies, which include projections, those are applied to the existing factual data. And there is no inconsistency, therefore, with the Court of Appeal reasoning, which said that there must be a factual foundation produced. And the way that the law works, where you need to engage in a forward-looking assessment, is actually clearly described in the Glaxo case, in the CJEU judgment. And if you have the second authorities bundle still open before you, that is at page 739. And interestingly, this now comes to a point that was raised by the court in argument a little bit earlier this morning. 93, as the Advocate General observed, an exemption for a specified period, because they're forward-looking at that point, may require a prospective analysis. It's therefore sufficient for the Commission, on the basis of the argument and evidence in its possession, to arrive at the conviction that the occurrence of the appreciable objective advantage is sufficiently likely to presume that the agreement entails such an advantage. I made that comment a moment ago because I think your Lordship said, well, in the European case law, they don't seem to talk about balance of probabilities. I do see here, for example, in the next paragraph, the Court of First Instance committed no error of law in the judgment under appeal in holding that the Commission's approach may entail ascertaining whether, in the light of the factual arguments and the evidence provided, it seems more likely either that the agreement must make it possible to obtain appreciable advantages or not. It's quite similar. So, therefore, there is no inconsistency with the object and purpose of the legislation if a court proceeds in this way, and there's no inconsistency with the spirit of the article if a court bases its decision on up-to-date information. And so far as Ms. Rose's submission about object and purpose of the treaty article is concerned, I say this. The object and purpose of the legislation is exactly what she said to this court on day one of the hearing. It is based on she made the submission based on paragraph 13 of the European Commission's guidelines. It's there to protect competition as a means of enhancing consumer welfare. That's what this is all about. And that objective is served by assessing the lawfulness of an agreement based on up-to-date and not historic information. Competition law would lose its effectiveness, and you would get outcomes that do not serve society well if you had to make a single one-shot assessment for all time, particularly in the case of long-lasting agreements. And there is Court of Appeal authority on this point, and that is why I felt it necessary to raise this. I don't know if this has been handed round, but I notified this to my friends yesterday. It's a case called Passmore and Moreland, which my Lord Lloyd-Jones may be well familiar with, because that was a case with Lord Justice Chadwick giving the lead judgment, which concerned the compatibility with this treaty article of an agreement over the lifetime of the agreement. It was focused on Article 101, paragraph 1, but the same principle applies as in relation to paragraph 101, paragraph 3. It was a beer tie, and there was a dispute between the tenant of a public house subject to the tie and the provider as to the lawfulness of the agreement and of the tie. And what Lord Justice Chadwick said, and I'll give you only a very brief reference to the salient paragraph, at paragraph 26 on page 1140, is that an agreement which is not within the treaty article, article as it then was 85.1, at the time it was entered into, because in the circumstances prevailing in the market at that time, it didn't have the effect of preventing, restricting or distorting competition in that case, may subsequently, and as the result of a change in those circumstances, come within the prohibition, because in the changed circumstances it does have that effect. And so one sees from this that there's, as it were, a running obligation on parties to consider whether their behaviour in implementing an agreement continues to be in line with the purpose and object of the treaty article. My Lord, I am grateful for the court's indulgence. I recognise that this will be taken out of my time.
Yes, it's about 30 minutes.
Well, in that case, some of it perhaps on the reply.
Thank you very much, Mr. Turner. Mr. Khan.
My Lord, thank you. Let me say first of all that the Commission is grateful to the Court for allowing the Commission to make oral argument in this case, and grateful to the parties for accommodating us in the timetable. I appreciate that the timetable is tight, and so to stave off what seems to be the inevitability of running out of time, on some points, I fear I won't be able to take your lordships to the relevant material, but only to give you references. Much of the material that I would otherwise be taking you to has already been adduced by the other parties. My Lords, the Commission took the exceptional step of intervening both here and below in the Court of Appeal because of the importance of this case to European competition law. It raises important questions about the coherence of the application of EU competition law. We thought that those issues had been settled, notably by the MasterCard saga in the EU courts, yet they're called into question by the schemes, which raise some fundamental questions about Article 101.1 and 101.3. Now, on the subject of the importance of EU law, that prompts one preliminary point. Reference has been made in argument by my learned friends to Section 60 of the Competition Act, which is the very first authority. It's in Volume 1, Tab 1. If we can quickly go to it. You were, for example, taken to it by Ms. Rose on day one in the context of her submissions in relation to Crean. Now, Crean is about, of course, the binding force or not of EU decisions, but the Competition Act deals with something different. Picking up on the question put by my Lord Reid on day one, page 87 of the transcript, Competition Act Section 60 refers to questions arising under this part and that are to be determined by reference to any relevant decision of the European courts as applicable at that time in determining any corresponding question arising in EU law. My Lords, we're not concerned here with corresponding questions arising in EU law. Here, we're concerned with questions arising in EU law. The reason that they're corresponding questions for the purposes of Section 60 is that EU law itself is not being applied. Section 60 is referring there to the mirror image of EU law in national law for situations which only affect trade within the United Kingdom but not between member states. So we would respectfully submit that Section 60 is simply not in point, at least on the questions of interpretation of Article 101 that we're concerned with. There's been a lot of argument about the autonomy of national proceedings. Now, Regulation 1/2003 clearly envisages this, but contrary to what the scheme suggests, that's not the end of it. Recital 5, on which such reliance has been placed, doesn't signify that Regulation 1/2003 confers complete national procedural autonomy. That regulation is very obviously subordinate to the competition rules of the treaty itself and general principles of EU law. Now, on day 2, in the transcript at page 11, my learned friend Mr. Hoskins, for example, acknowledged general principles, including that of uniform application, but suggested that this could somehow be balanced against the principle of subsidiarity. That, I'd submit, is not a correct analysis. Subsidiarity concerns the prior question of whether an action should be taken at EU level or at national level. As regards the competition rules, the EU obviously already has acted, and so the relevant general principle is that of the uniform application of EU law. There is an authority in the bundles that mentions that. I don't think I need take the court to it. If I could just refer your lordships to it. It's the Austrian freight forwarding cartel case. It's in volume 8 of the authorities, tab 67, page 3460, and the specific passage in question is at paragraphs 34-35, which is at 3493. So, my lords, turning to the issues in the appeal, on Article 101.1, I think I can be very brief. The first immediate reason for this is the submissions already made on behalf of the merchants by my learned friends Mr. Turner and Mr. Brearley, and then more generally, despite the immense duration of the MIF saga, with the Commission having received a notification first from Visa under Regulation 17 in 1977, the arguments remain fundamentally unchanged. Much of the scheme's argument was to classify everything in the decision and the EU judgments as fact, but it's obvious from the arguments in the decision that the Commission could not have made findings of an infringement without reaching conclusions of law. The same, of course, applies to the judgments. And we would submit simply that the Court of Appeal was entirely correct to find that there's no material difference in the facts. That has all been addressed by the merchants. I will only make a couple of very short points. My lords, on day 1, my learned friend Miss Rose maintained that the MasterCard 2007 decision is all explained away for the purposes of this case by the prospect of bilateral negotiations and in the absence of the MIF. And on day 1, this is page 94 of the transcript, Ms. Rose seemed to link this to evidence from the merchants. Having referred to Mr. Justice Phillips' judgment on this point, she said what is important is that the Commission here identified a competitive process of negotiation which it finds, on the basis of evidence from retailers, would occur in the counterfactual situation. My lords, it's correct that recital 460, much debated part of the decision, does refer to evidence from retailers, but the evidence from the retailers that is referred thereto is in support not of the purely theoretical prospect of bilateral negotiations, but in support of the point on which the decision rests, which is the issue of the floor under the interchange fee. The reference there is in Appendix Part 1D, electronic page, it's page 7026, I think. That's recital 460, and the footnote is referring to evidence from 2 retailers, British Petroleum and IKEA, which is at, that's at recitals 222 and 228 of the decision. I'm sorry, my lords, I have a first edition of Appendix Part 1D. If I can just leave you with those recital references. I'm very grateful. Yes, well, your Lordships will see there that the evidence from British Petroleum, for example, makes no reference to bilaterals. After all, bilaterals would take place between acquirers and issuers. British Petroleum is simply complaining that the interchange fee puts in effect a floor under any negotiations on the merchant service charge. And then, just lastly, on Article 101, I should address briefly the implications of the interchange fee regulation, which is in Volume 1 of the Authorities, tab 15, page 432. Now, with respect to the interchange fee regulation, Ms. Rose seemed to argue on day one, this is page 48 of the transcripts, but the very existence of the regulation proves her case. Ms. Rose arguing that there's no regulatory gap here, there's no mischief that means that there's a pressing policy reason to try to adopt an expansive meaning to Article 101.1. Of course, first of all, we would submit that there's no expansive reading involved here. The restriction of competition falls squarely within paragraph 27 of the Commission's horizontal guidelines to which you have been taken. And in any event, one can't interpret the scope of competition law by saying that if something can be regulated, it's not susceptible to competition law. That just doesn't work under the EU treaty because there's no hierarchy of instruments. And you see that borne out in the regulation. If one turns on to page 433 in the bundle, recital 10, for example, it says towards the bottom of recital 10, in addition to a consistent application of the competition rules to interchange fees, regulating such fees would improve the functioning of the internal market and contribute to reducing transaction costs for consumers. And similarly, recital 14 on the next page, page 434, says that the application of this regulation should be without prejudice to the application of union and national competition rules. So the regulation recognises the desirability of applying both the competition rules and regulation to MIFs. Its adoption reflects the fact that the Commission can't take on the administrative burden of investigating every MIF agreement. I mentioned earlier that the Commission received its first visa notification in 1977, and the Court will have seen there's a commitment decision as recently as 2019, which was part of a package which mercifully brought the saga to an end, but that's quite a long period to be investigating something. My Lords, I should turn to Article 101, paragraph 3. Let me emphasise at the outset that the Commission is, of course, not taking a position on the ultimate merits of the scheme's claims. It's only addressing the principles by which they are to be assessed. On the first point about evidence and proof, we've submitted in our written case, paragraph 32, it's in the core volume, page 5172, that this is really about the nature of the evidence required to substantiate an exemption. But briefly, on the issue of the standard of proof, we will endorse Mr. Brearley's remarks to that effect. And on the question about the standard of proof put by my Lord Reid, inquiring whether there was any mention in the European jurisprudence of the balance of probabilities, well, there's something to that effect in a case in the bundles which has been shown to the Court. That's the GSK case, which is in the second bundle of authorities.
I'll take your word for it if you give us a reference.
That's very kind, my Lord. It's at page 633. It's paragraph 249. It doesn't refer to balance of probabilities in those terms. It refers to more likely than not. So it puts it in similar terms. I would just say that that has to be read subject to a caveat entered at paragraph 280, because the court, having mentioned the standard of whether it was more likely or not that the agreement would make it possible to obtain appreciable advantages, paragraph 280, at the very end of that paragraph, having referred to paragraph 247, 248, the court then says that any advantage in the form of a gain in efficiency must therefore be taken into account, provided that it is objective and appreciable and that its existence is proved convincingly. So there's some modulation of the standard there. But on the question of the nature of the evidence, which we submit is really the heart of the problem, the schemes rely on Recital 5 to Regulation 1/2003 and claim from that the autonomy left to national legal systems on standard of proof means there must be a similar autonomy afforded regarding the nature of the evidence. That, I'd submit, is greatly overstating the import of Regulation 1/2003. As I've mentioned, it's a regulation implementing the treaty's competition rules and is subordinate to those rules and their interpretation by the court. Furthermore, it's only a recital. Now, although Articles 101 and 102 are expressed as substantive rules, their interpretation by the court includes some evidential rules. So to pick up on my Lord Reed's question on day 2, at page 16 of the transcript, indeed, there's a general rule under the treaty that enforcement must not be rendered excessively difficult. When that was put to Mr. Hoskins, he took that as an invitation to argue that one must therefore not make exemption under Article 101, paragraph 3 impossible, which is fair enough as far as it goes. One has to bear in mind that one is starting from a position of an infringement having been established under paragraph 1. And still on the subject of general principles, there's the general principle of legal certainty, which has just been addressed this morning by my learned friend Mr. Turner. On that, I just briefly mention, but I don't need to take the court to, an authority in volume 10 of the authorities bundles, tab 83, page 4667, Shaw and Fowler, which is one of the, which is the less celebrated aspects of the beer tie saga than, of course, the famous Crean case. That's a case where there was a challenge to one of those commission decisions which did grant an exemption to the tied house system. I think it was of Whitbreads or Scottish and Newcastle. And there the court will see the analysis of the exemption and the approach which reviewed the situation over a number of years as time went by. But returning to the question of the nature of evidence required here, the court was taken to the E. Turas case, and we submit that that's a case which shows that there are other more specific rules that can arise under the treaty, and we submit that Article 101.3 is an instance of such specific rules. Perhaps we could turn up E. Turas, which is in volume 2 of the authorities bundle, tab 18, page 536. The judgment itself begins at page 556. Begin by noting the obvious, that this is a reference from a national court, and as we will see, that at the very least modulates Mr. Hoskins' suggestion on day 2, page 28 of the transcript, that not only the standard of proof but the nature of the evidence required to apply Article 101.3 can be different somehow, depending on whether you are before an instance of the EU or before a national court. So turning on in the judgment at paragraph 25, you see the question put by the national court. It's a question about information sharing and when a presumption arises which would engage liability under Article 101. And the court answers that question starting around paragraph 35, reminding the national court at paragraph 37 of the principle of effectiveness, and that an infringement may be proven not only by direct evidence but also through indicia. Then, having given the national court some guidance about the question that is asked, namely the potential triggering of the presumption of liability, although it wasn't asked about it, the Court of Justice goes on to give some rather more specific guidance, in fact, about how that presumption might be rebutted. If one turns on to paragraph 46, which is page 563, there the court recalls in the third place, it must be pointed out that a travel agency may rebut the presumption that it participated in concerted practice by proving that it publicly distanced itself from that practice or reported it to the administrative authorities. I'll just pause there to explain that this is a well-known principle in relation to cartel practice. If you're a participant in cartel meetings and you wish to deny your participation, then you must publicly distance yourself from the cartel. It's an example of an evidential rule laid down directly from the treaty. And the court goes on to say, in addition, according to the case law of the court, in a case such as that at issue in the main proceedings which does not concern an anti-competitive meeting, public distancing or reporting is not the only means of rebutting the presumption that a company has participated in an infringement. And then at paragraph 49 on the next page, page 564, it enlarges on that and explains how and by what type of evidence a means of rebutting the presumption might be achieved in the circumstances of the case. So as we've noted in our written case, paragraph 34 in the core bundle, page 5173, ETURAS is further explained by Advocate General Spunar's opinion in that case, which you find, if you still have the case open at page 555, 555, where I just draw the court's attention to paragraphs 99 and 100 of the Advocate General's opinion, where he explains that presumptions under Article 101 form an integral part of applicable EU law. They do not fall within the scope of the principle of autonomy of national procedural law and are therefore binding on national authorities when they apply EU competition rules. So, my lords, the case illustrates how the nature of the evidence by which a finding of infringement can be secured or can be rebutted may be a question of EU law. Now, I should move along to consider matters closer to home in the form of practice by the Commission in commitment decisions, which is relied on by the schemes.
Can I just ask before you move
Sorry,
on?
Lord, yes.
Just to be quite clear, we see European judgments speaking of things having to be proved convincingly. We have the English standard of proof on a balance of probabilities. Does the Commission have any concerns about a potential disparity between those standards?
It's in the light of the potential modulation of the English standard that you see through cases like Ray B.
would your approach be then, in this sort of case, Article 1011, infringement has been prima facie established, so you have a restriction of competition, and we are in the territory of the lion in Regent's Park, that one needs good quality evidence to show that it's more likely than not that there were the benefits that 1013 requires. Is it that sort of means of melding the two systems that you're looking to, or do you have a different position?
I don't know if we'd go quite so far as to suggest we're in lion territory.
That's why I referred to a wild cat
question.
earlier.
It all, of course, depends very much on the circumstances.
Yes.
Everybody is agreed on that. But one does have to bear in mind that one is starting from a situation where an infringement has been established. We have the judgment in GSK, which I took the court to, where on the one hand, indeed, the court refers to what appears to be, in terms, a balance of probability standard, but then slightly qualifies that by referring to the need for convincing evidence. I don't think one can devise some kind of universal rule or form of judgment to say that member state X's standard of proof is adequate and member state Y's isn't.
Could I ask you one more question? You referred us to the regulation, 1 of 2003. I wondered if Article 16 was something that had any application here.
Article 16 is...
I should say one finds it in Bundle 1, tab 16,
yes,
on page 459.
A very familiar provision. It's in effect the statutory implementation of the Master Foods principle, which was one of the key considerations in the House of Lords decision in Crean. Yeah. No, I would not say that we are in Master Foods Article 16 territory. It's rather that, given that, as the Court of Appeal found, correctly in our submission, that the essential facts on which the finding of infringement is premised are the same here and in MasterCard 2007, then it's a question of a binding principle of law in the circumstances.
I understand. That's very helpful. Thank you.
Thank you, Madam. Coming to practice in Commission commitment decisions, I emphasise these are only commitment decisions, although they're prayed in aid by the schemes as being, in effect, Article 1013 decisions. Now, Mr. Hoskins, on day 2, page 45 of the transcript, said that the Commission practice was not to insist on empirical analysis and data, and yet in taking the court through the 2019 commitments decision, as he did, my Lord Sales observed that it showed that the Commission was working on empirical data. And Mr. Hoskins' only answer to this was to say that the data there was the same type as MasterCard relies on in this case. Well, that may be so, but it obviously doesn't make good my learned friend's claim about the Commission's practice. I don't need to dwell on the point that the Commission requires empirical evidence even for commitments, but just want to emphasise that there are limitations to the merchant indifference test and the use of commitment decisions as some sort of guide to practice under Article 101.3. You also, I think, been taken to the 2014 visa commitments decision. If we could perhaps just go there again, that's in Appendix 1D, page 7210. And the relevant section begins page 7233. Recital 109, I think that, yes, 7233, I think that is, which is again a reference to empirical evidence. And then further down the page, this is explained as the Commissioner having indications that the myths derived from those studies would make a merchant indifferent between accepting a cash payment and a card payment. But the decision makes it very clear that that doesn't equate to an application of Article 101, paragraph 3. That's clear from the previous page, 7232, at the bottom, recital 107, which is full of qualifications, states that economic theory indicates that the MIFs which comply with the MIT should allow merchants and customers to benefit from increased card use to the extent that the MIFs are passed on to the cardholders by the issuers. They ensure that cardholders make efficient choices. So the Commission there is making a very considerable concession in the form of to the extent that the MIFs are passed on to the cardholders. An issue which has been quite a battleground in the litigation below. The Commission is also conceding that the increase in card use will be beneficial, which, as we'll see, is not something that would be taken for granted in an Article 101.3 decision. Before leaving that decision, if you turn back to page 7210, yes, you will see that the matter began, this particular chapter, in the interchange fee saga, in the Commission decision of the 6th of March 2008 to initiate proceedings. So the Commission understandably had an interest in bringing matters to a close expediently. Had those been Article 101.3 decisions, the methodology would have been much more demanding. And you can see this in the context of card payment systems from the court's judgment in the carte bancaire case, which has been mentioned, but I don't think the court's been taken to it. It's in Authorities Volume 2, tab 28, page 1323. Sorry, it's Volume 3.
Yes.
Back to your
The MS page?
sorry, Lord, it's 1323 is the beginning of the case. And just to explain the context, if one turns over to 1324, you'll see that it's about the carte bancaire group, which is a payment card system, and it's explained in paragraph 3 that the group had 148 members. Those members are either institutions called leaders or institutions forming part of one of the leaders. And going down to the bottom of the page, Carte Bancaire notified, it explains in paragraph 8, its agreement, which involved a fee called the NERFA, which you see explained over the page 1325, paragraph 18, which is described as, in the jargon of this case, as a balancing fee. The difference being it's internal between banks. It's a fee paid between banks whose activities relating to acquisition are significantly lower relative to their issuance activity. They're the ones who are subject to the fee. And the ostensible justification for this was not to reduce competition, but to make those who benefited from the fruits of issuing cards, but who didn't participate in acquiring activity or in running the facility of cash machines, pay what was seen to be their fair share for the running of the system. don't think I can take you through the whole case, but I just invite the court to turn to page 1377, which deals with some of Carte Bancaires 1013 claims. Those begin at 1369, which is headed in the middle of the page on the fourth plea, about Article 81, paragraph 3 as it was. And you'll see various arguments deployed over the successive pages about whether or not Article 101.3 had been satisfied. I think given the constraints of time, I'll just limit myself to referring the court to paragraph 422, which is on 1377, where the court observes that since the justification of the MRFA as an equilibrating mechanism, I add that this is an unofficial translation, I think they mean balancing mechanism between the acquisition and issue activities is based on the premise that the acquisition activities generated greater positive externalities compared to those generated by the issue activities. And since it's clear from the contested decision that the group was not able to demonstrate that this premise was correct, it must be found that the Commission rightly concluded that the group had not demonstrated the need to encourage acquisition over issue. Therefore, it did not demonstrate that the MRFA was justified as a remedy for the second source of parasitism, free riding. My Lords, I just conclude on that by submitting that it shows that Mr. Hoskins also falls well short of his submission that pure economic theory could be enough to secure an exemption, which was his argument on day 2, page 44 of the transcript. The unfettered evaluation of evidence principle on which he relied is indeed generally applicable, but as one sees from cases like Ituras, that's subject to specific requirements that have been developed for certain specific situations. On the Commission's practice, coming even closer to home, it's useful to refer perhaps to the Visa 2 decision, which was relied on by my friend Miss Rose on day 2, page 103 of the transcript. Visa 2 is also in bundle part 1D of the appendix, page 7185. It was cited as an example of how 101 paragraph 3 should not and has not been made excessively difficult. The Carte Bancaire shows that Visa 2 is hardly representative of current requirements. If you just compare recital 83 of the Visa 2 decision, on which Visa relies, that's at page 7185, which accepts the maximization of output approach to assessing benefits. If you compare that with Carte Bancaire paragraph 422, which I took the court to, there you'll see that the European Court took a much more rigorous approach. It's important in understanding Visa 2 to bear in mind the background. First of all, these cases are concerned with claims in the United Kingdom, which is a particularly well-developed market for cards. The Visa 2 decision is a decision which, of course, applies throughout the EU and has to take account of other markets where card usage, certainly in 2002, was considerably less well-developed, hence perhaps the acceptance in recital 83 of the output maximization argument. And also the decision is founded on finding a restriction. This is recital 66. I'm sorry, I don't have the electronic number. I think that would be 7182. Finding a restriction in both the issuing and acquiring markets. So again, that's not the same here, where the focus is on the acquiring market and as we've submitted, so the benefits must also be on the acquiring market. You can see how much the situation had changed even by 2007 by reference to the 2007 MasterCard decision. I mentioned the United Kingdom was always ahead in card use. If one looks at the MasterCard decision, recital 319, which is in Appendix 1D, page 6988, you'll see there a statement about how the average number of transactions with credit cards per inhabitant in the United Kingdom is 4 times higher than in Spain, 6 times higher than in Germany, and more than 10 times higher than in Sweden. The 2007 decision shows, therefore, that there have been market developments and also that the scheme rules had changed. I'll just refer the court, I don't need to take you to it, to recital 216, page 6962, about changes in rules which, according to the complainant merchants anyway, diminish the utility of the payment guarantee. So it forms a counterpoint to Visa 2. You'll see similarly at page 7083, recital 688, that output maximization was not accepted there as synonymous with efficiency. And that's consistent with the Commission's recent work in the cost of cash study, which I'll just mention the reference to of Appellants Additional Documents, tab 15, page 7626. My Lord, if I could just lastly, I think, tackle the question of fair share. Again, Mr. Brearley took the court to the guidelines on Article 101, paragraph 3. That's volume 3 of the authorities, tab 30, page 1616. And Mr. Brearley's analysis of point 85 of the guidelines, page 1629, prompted a question from my Lord Sales about the relevance of the reference in footnote 80 to Constant and Grundig. As your Lordship pointed out, the reference did appear to be rather misplaced. The explanation appears to be that, as the footnote states, which is on page 1637, the case is about the first condition, and indeed the passage in the guidelines there is about the second condition. The relevance of the reference appears to be that the case is cited not in direct support of the proposition made there in point 85 about fair share, but just to make the further point, also made by Mr. Brearley, that the benefits claimed to provide the fair share must show advantages of such a character as to compensate for the restriction. It's the scheme's case that on that second condition, the fair share condition, MasterCard ECJ is in their favour. But that presupposes that the ECJ was addressing the fair share question. This is a point that's been addressed by Mr. Turner this morning. To that, I would just add that since it's clear that the first instance court was stopping its analysis by rejecting the attack with respect to the first condition, then it simply wasn't open to the Court of Justice on Appeal to make any binding pronouncements on the second condition. The first instance in Luxembourg is a judicial review of the decision, but it's important to bear in mind that an appeal to the Court of Justice is a review of the judgment, and the judgment on the appeal can't go beyond reviewing the judgment below. If the judgment on appeal means that certain issues dismissed as irrelevant at first instance are not covered in that first instance judgment now become live issues, then the Court of Justice can either send the case back for consideration of those now live issues or take over the role of the first instance court itself. But if it were to do that, it would do it in a clear and separate section of the judgment, and that didn't happen here. So we say the Court of Justice judgment doesn't offer any assistance here. And on the merits of the fair share point, our submissions, we say, accord with the logic and the scheme of Article 101.3. If a restriction has harmed certain consumers, and if that restriction is nevertheless to be exempted because of the countervailing benefits, it's only logical and just that those benefits should be benefits accruing to the same class of consumers. That leaves the knotty question that was troubling the court yesterday afternoon on the interpretation of the Court of Justice's judgment in MasterCard as regards that first condition. My lords, I can only say that although overnight I looked at the original French version of the judgment in hope that I would find a bug in the translation that would explain it all away, I'm afraid I didn't. The translators made a masterful task of conveying the sense of the judgment as it was surely originally written in French, and we accept that on the interpretation of the first condition, it's not easy to understand. We've mentioned in the conclusion of our written case that if the court were to consider that the scheme's arguments had merit, then the appeals couldn't be disposed of in their favour without there being a reference to the Court of Justice. The issue of the first condition is not an issue formally in the appeal, but if the court were minded to make a reference, that is, of course, a question that could be referred to the court for clarification. My lords, I don't want to outstay my welcome, so unless the court has other questions for me, those are our submissions.
Thank you very much, Mr. Khan. The court is grateful to the Commission for its submissions.
Thank you.
Ms. Rose.
My lords, there is consensus between Mr. Khan and myself that the test within the parameters with which this court's concerned in relation to the first issue is not about Regulation 16 of the modernisation regulation, but rather, as he put it, he says, given that the essential facts found in this case are the same as the facts in the MasterCard case, the conclusion of law that there was a restriction of competition in that case ought to apply in this case too. I agree that that is the issue, and therefore the question is whether or not it is right that the essential facts found by Mr. Justice Phillips in these proceedings are in fact the same as the essential facts that were found in the MasterCard case. And fact includes the primary fact about what a MIF is and how it operates, the what you might call counterfactual hypothetical fact of how competition works in the counterfactual situation, and then his evaluative conclusion about whether there is any difference between competition, between the counterfactual as he has found it to operate competitively and the MIF as he has found it to be. That's the question. Now, there's also consensus between Mr. Brearley and myself. Mr. Brearley correctly identified yesterday the structure of the Commission's decision, and in particular, that the Commission identifies the argument that was being made by the appellants in that case as being, well, the restriction, there's no restriction because competition is the same in the counterfactual, and it addresses that question at paragraphs 455 to 460 of its decision, which are at Appendix 1D, and it's MS 7025. Now, we need to turn this up, I hope now, for the last time.
Sorry, we're going to 1D.
1D 7025, my lord.
Thank you.
It's the key paragraphs, 455 to 460, where you see the heading MIF, not a restriction, because effectively like an excise tax. And Mr. Briley's right to say this is the passage where the Commission rejects a similar argument that we're mounting in this case. And the two key paragraphs are 458 and 460. And at 458, they say the MasterCard myth not only creates an artificial common cost and thereby sets a floor, acquirers also know precisely that all their competitors pay the same fees. The price floor and the transparency of it eliminate an element of uncertainty. And there you see the two key findings of fact. First, the myth creates an artificial price floor, the counterfactual doesn't. And secondly, with the myth in place, there is no uncertainty about the terms of your competitors. Without it, there is an element of uncertainty. Those are the two key factual points on which this decision turns.
Because although there was a common cost, it would be open to the merchants to try to negotiate with the acquirers to bear part or all of that cost themselves.
Yes.
If it wasn't for the fact that the acquirers were maintaining a common front.
Exactly. Your Lordship is exactly right. It's the multilateral agreement, which is transparent to everybody because it's in the scheme rules, that means that you can't negotiate. That's the point. And as we shall see, the critical difference in the finding of fact that Mr. Justice Phillips makes is that he appreciates that the same is true under the SAP rule. Exactly the same condition applies. So that's 458, and you can see that it hinges on those two findings which are said to reduce uncertainty. And as we saw on day one, the reduction of uncertainty is a critical element in the question of restriction of competition. That your Lordships will recall, that was the ASNEF Equifax case and the guidelines. And then we get to 460. And 460 is the paragraph in which the Commission conducts the comparative exercise between competition in the factual situation and competition in the counterfactual. This is the essential exercise that has to be done for an effects case. And we see the following points from this paragraph. First, this is a factual conclusion which is expressly based on the evidence of retailers. That's the opening passage. Now, Mr. Khan says, oh, well, when you look at the summary of the evidence of the retailers, it doesn't seem to say very much. But that might be a reason for criticising the correctness of the Commission decision. But it can't turn what is on its face here, a finding of fact based on evidence, into some different kind of finding. Might mean the Commission got it wrong, but that doesn't concern us because the National Court has to assess the facts for itself. So that's the first point. The second is that the focus, as we can see, is on the pressure that merchants are able to apply to acquirers in the counterfactual that they're unable to exert in the factual situation. That's the question that's being addressed. And that's the right question because that goes to the question of competition and rivalry. We then see in the next sentence the reason why the Commission thinks that retailers can apply more pressure in the counterfactual than the factual. We can see that's the reason why because that sentence starts, this is because. This is the reason why they can exert the pressure. And this is because without a default that fixes an interchange fee rate in the absence of a bilateral agreement, merchants could shop around to contract with the acquirer who incurs the lowest interchange cost. That is a finding of fact that there would be a form of competition between acquirers which would enable merchants to shop around in a way they cannot shop around now. In other words, the common input cost that applies in the factual is not applying in the counterfactual. Again, right question, because it's talking about competition. But why? Why can the merchants shop around in the counterfactual when they can't shop around in the factual? The Commission tells us in the next sentence. Acquirers who bilaterally agree to pay relatively high interchange fees would ultimately not remain competitive. Other acquirers could undercut their fees by refusing to enter into bilateral agreements with issuers or agreeing on relatively lower interchange fees. The uncertainty of each individual acquirer about the level of interchange fees their competitors bilaterally agree to pay to issuers would exercise a constraint on acquirers. That is a description of a competitive process between the individual acquirers and individual issuers, which the Commission is finding as a fact will occur in the counterfactual situation. And as your Lordships know, Mr. Justice Phillips, after an exhaustive consideration of the evidence, concluded that was wrong on the facts of our case. Might have been right or wrong on the evidence for the Commission, we don't know. But it didn't apply to this market and these MIFs because Mr. Justice Phillips found there would be no such process. Then they go on to say that in the long run, this process can be expected to lead to the establishment of interbank claims and debts at the face value of the payment without deducting any interchange fees. And what the Court of Appeal said, and what my learned friends say, is, oh, well, this competitive process doesn't matter because it's transitory. That was what Mr. Turner said. It's transitory, and you end up anyway with a zero MIF or settlement at par. That's missing the point. The point that the Commission are making here is that that is reached as a result of a competitive process, market forces operating between acquirers which don't operate in the factual situation. And that's why there's a restriction of competition by comparison with the counterfactual. It doesn't matter whether bilateral agreements, there are some in the short term, but they wither on the vine in the long term. It doesn't matter whether there are no bilateral agreements at all. What's important is the uncertainty leads to a competitive process, leads to negotiation, leads to the ability to shopping around. That's the point. And the finding of Mr. Justice Phillips is none of that process happens in the counterfactual as well as in the factual. And then they say a multilateral rule that by default sets a certain interchange fee rate in the absence of bilateral negotiation prevents this competitive process. And my lords, the critical finding of Mr. Justice Phillips is so does a SAP rule. The finding of Mr. Justice Phillips is a multilateral rule that by default requires settlement at par in the absence of bilateral negotiations prevents this competitive process. You can plug in Mr. Justice Phillips's counterfactual to this sentence, and that's the reason why he reaches a different result. In the absence of such a rule, and in the presence of a prohibition of ex post pricing, acquiring banks would eventually end up setting their MSCs merely by taking into account their own marginal cost plus a certain markup. That's their view of the long-term outcome of a competitive process. Again, different from Mr. Justice Phillips, who says there never would be any such competitive process. So that's 460. And footnote 517 to this very paragraph tells us to read this passage together with section 7.3.4.1 of this decision. And that section includes paragraph 554 that we looked at. It's at 7049. And paragraph 554 is the paragraph that discusses the relative restrictive effect of a MIF and an ex post pricing prohibition. And it says in the last sentence that that solution, the ex post pricing prohibition, is less restrictive of competition than a MIF, as it does not set a minimum price level on either side of the scheme. Again, a finding of fact different from Mr. Justice Phillips. So essentially, what the Commission has found is that the MIF sets a floor on the MSC because it is a common input cost which restricts the way that merchants can negotiate with acquirers. But the counterfactual ex post pricing mechanism does not set a floor on the MSC because of all the reasons we've looked at 460 and 554. That's the point. So whenever you see in the Commission decision or the General Court judgment or the CJU, the statement, the MIF sets a floor on the MSC, or the MIF inflates the price, and that's why it's a restriction of competition, what you need in parenthesis is, and the counterfactual doesn't. Because if the counterfactual also sets a floor on the MSC, then there's no restriction of competition. So those are the findings of fact of the Commission. What then happens is those findings are upheld by the General Court expressly on the basis that they are findings of fact which don't disclose any manifest error. And those are the actual terms in which both of the findings of fact we've both looked at are upheld by the General Court. We've looked at it before. Let me just give you the paragraph, the references. So Authorities Bundle 2, tab 24, MS 944, and it's paragraphs 95 and 96, which deal with the finding at 554 and say that that's reasonably open and there's no manifest error, and 133 and 134, which deal with 460. Those conclusions of the General Court upholding the findings of the Commission about what competition looks like in the counterfactual are the factual foundation for the conclusions of the General Court at paragraphs 142 and 143. And I do just want to look at this. We're in Authorities Bundle 2. It's MS 951. These are paragraphs on which Mr. Turner in particular placed very heavy reliance. And you can see the argument is still being maintained before the General Court by the schemes. They say the prohibition of ex post pricing would effectively impose a MIF set at zero, which from a competitive aspect would be equivalent and just as transparent as the current MIF, the only difference being the level at which it's set. Now, the problem for the schemes is they're trying to argue that both the MIF and the counterfactual set a floor under the MSC, they just set it at a different point, in circumstances where the Commission has already found that the counterfactual does not set a floor under the MSC, does not set a minimum price on either side of the scheme, and therefore is less restrictive. So that argument is hopeless. It's going to fail. Once they've failed to challenge the findings of fact, their challenge to the conclusion is bound to fail. And that's exactly what the General Court says in the following paragraph. This line of argument cannot be accepted, since it is acknowledged that the MIF sets a floor for the MSC, and insofar as the Commission was legitimately entitled to find that a MasterCard system operating without a MIF would remain economically viable, in brackets, and that would be less restrictive because we've upheld 554, it necessarily follows that the MIF has effects restrictive of competition. And then they explain that conclusion. By comparison with an acquiring market operating without them, the MIF limits the pressure which merchants can exert on acquiring banks when negotiating the MSC by reducing the possibility of prices dropping below a certain threshold. So they are there picking up the language of 460. And as I said before, 460 is the only passage in the Commission's decision where you find this reference to the MIF limiting the pressure that merchants can impose on acquirers. So my Lord Reid said, well, this is obviously a finding of law because it says it necessarily follows. And my Lord, it does necessarily follow, but only on the basis of the findings of fact that have been made and that are here upheld. And of course, when we get to the CJEU only has jurisdiction over issues of law. The CJEU cannot reopen the facts at all. And the point becomes even clearer if you look, we're still in the same volume, it's MS 1059, paragraph 112. The General Court, in its definitive assessment of the facts, see that? The definitive assessment of the facts, held that the Commission was fully entitled to conclude that the prohibition of ex post pricing was less restrictive of competition as it does not set a minimum price level on either side of the scheme. So there you see the CJEU in its discussion acknowledging that there's that key finding of fact at 554, that has been upheld as a finding of fact by the General Court, and that is now a definitive assessment of the facts with which the CJU cannot interfere. And that's the context in which we come to paragraph 195. And the complaint that the schemes are making, which is being addressed at 195, is they're saying the Commission and the General Court keep saying there's a restriction of competition just because the MIF sets a floor. And that can't be right, because an agreement that results in a higher price is not per se a restriction of competition. So they are taking the reasoning, which of course now Mr. Turner tries to rely on against me, to say there's an error here by the General Court which hasn't done a counterfactual analysis. It's simply said that the MIF restricts competition because it raises the price. And the Court of Justice says, no, that's a misinterpretation of the decision of the General Court. We see this at 195. The appellants cannot criticise the General Court for having failed to explain how the hypothesis applied had less restrictive effects on competition than the MIF, given that the only difference between the two situations lies in the pricing level of the MIF. They can't criticise. Of course they can't criticise it because a different finding of fact had been made that we've just seen. And they go on to make this point. As the Commission rightly points out, the judgment under appeal is not based on the premise that high prices in themselves constitute an infringement. So they are not saying that merely because an agreement increases the price for consumers or puts a floor under the price, that is a restriction of competition. On the contrary, as is apparent from the very wording of 143, high prices merely arise as a result of the MIF, which limits the pressure which merchants could exert on acquiring banks, with a resulting reduction in competition between acquirers as regards the amount of the MSC. So what actually happened in this case is that there was some slightly loose language used by the General Court which appeared to suggest that the mere fact that the MIF sets a floor under the MSC per se is a restriction of competition. That complaint is made to the CJU on appeal, and the CJU clarifies to say, no, that's not what the General Court was saying. What they were saying is the restriction of competition here is because the MIF limits the pressure that merchants can put on acquirers, and that's the reason why the price goes up. So, my lords, in my submission, when you look at the process as a whole, it is very clear, as it has to be, because this is an effects case, not an object case, that the conclusion of a restrictive effect on competition is based on the findings about how the MIF operates, how the alternative counterfactual operates, and how competition operates in each of those two situations. Mr. Justice Phillips, as your lordships know, made very different findings of fact. Now, I don't have time to go back to these in detail, but I'm just going to list them and give you the relevant paragraphs. First, he found that settlement at par and the MIF were both equally transparent collective settlement rules. That's paragraphs 80 to 82, Core Volume 2, 5775-6. Second, they both determine the terms on which issuers and acquirers settle their transactions. The difference is simply that under the MIF, the issuer is obliged to pay 99.8% of the face value of the transaction to the acquirer, and under settlement at par is obliged to pay 100%. Thirdly, settlement at par is not no charge. It's an obligation on the issuer to pay 100% of the transaction value to the acquirer. In return, the issuer does not receive the goods for which the merchant is getting the money. What the issuer gets is the right to recover that sum from the cardholder. But the issuer takes a risk. He takes the risk that the transaction was fraudulent. In that case, he still has to pay 100% of the face value, but he won't recover and has no right to recover anything from his cardholder who didn't actually make the transaction. This is a purely financial transaction which places a liability on the issuer. The question is simply whether that liability is 100% or 99.8%. Mr. Justice Phillips, of course, a very experienced commercial court judge, understood this, and it's the focus of his critical findings at 80 to 82. And he appreciated that what that means is that it is wrong as a matter of economic analysis to say that settlement at par is in any way a neutral or baseline or natural answer to the question how much issuers should pay to acquirers for the right to recover the transaction price from their customers. And you'll see that he deals with this at paragraphs 134 to 135 of his judgment. What is the right or appropriate or efficient price for this transaction to settle at depends on the assessment of the costs, benefits, and risks between issuers and acquirers in a contract of this kind, just as it does, for example, in an invoice factoring contract, which is similar. There is, of course, a very important difference between this situation and a factoring agreement. And the difference is that in such an agreement, the individual parties on each side would be agreeing as between themselves what is the value of the invoice, whether it's worth 100% or 98% of its face value. But in this case, it is common ground that that won't work. The only way the schemes can function is if that question of what are the terms on which these transactions must settle in default of bilateral agreement is a common cooperative agreement. That's the critical importance of that finding. Has to be set multilaterally. So the SAP rule, the counterfactual, is a collective agreement that allocates costs and revenues to each side of the platform. And it does that to exactly the same extent as a MIF. It just gives them a different value. And that's why the finding at 554 of the Commission's decision is wrong as a matter of economic analysis, as a matter of fact. The counterfactual does not involve issuers and acquirers competing for the business of cardholders and merchants solely on the basis of their individual costs of actions they've chosen to take. And when the Commission found at 551 that that was the counterfactual, that is contrary to the facts found by Mr. Justice Phillips. They always take as a starting point the amount that the scheme rules require issuers to pay to acquirers on each transaction, whether that is settlement at par or some different figure. Now, as Mr. Justice Phillips then pointed out at paragraphs 103 to 4, it is a restriction of competition for the terms on which these transactions settle to be decided multilaterally. But the restriction of competition is the same whether the terms are settlement at par or under a MIF. The restriction of competition that exists in this case is a restriction that everybody agrees is necessary for the schemes to function. Mr. Justice Phillips then went on to find that the competitive process between acquirers for the business of merchants is identical under the MIF as under the SAP. In both situations, issuers and acquirers have the same degree of certainty about the terms on which their competitors settle. In both situations, all the acquirers know that the scheme rules provide for how much the issuers are to pay. The incentives not to agree a bilateral are identical under the factual and counterfactual situation. That means there is no increase in uncertainty in the counterfactual situation. In both, the only incentive is for everybody to contract at the level of the default rule. In neither case can the merchant shop around or apply pressure to drive the MSC below the level that reflects the default settlement terms. And that is a finding made by Mr. Justice Phillips on the basis of AAM's own expert witness, Mr. Dryden, at paragraph 1591. Mr. Turner wrongly said yesterday that there was no such finding made by Mr. Justice Phillips. It was made in that paragraph, and it was based on Mr. Dryden's own position. You can see what Mr. Dryden's position was very quickly. If we go to Appendix 1C, the joint expert report from our case, it's at 1365. That's the internal numbering. The MS number is 6555. So these are the...
I'm sorry, that last number?
Sorry, it's Appendix C, 1C, my lord.
Yep. Yes, I didn't catch the page number.
6555.
Thank you very much.
And you can see the issue, and then you see the position of each expert in relation to it. So the issues here is, do MIFs affect the intensity of competition between acquirers? Your Lordship see that. Is this relevant for the assessment of restriction of competition? And Mr. Dryden, the claimant's witness, says no. In other words, MIFs do not affect the intensity of competition between acquirers, but not relevant, as I find a restriction due to the effect of MIFs on MSCs, and the level of MSCs affects consumer welfare. And we see Mr. von Hinton-Reed, who was Sainsbury's witness, simply says this is irrelevant. Whether or not the MIFs affected the intensity of competition between acquirers does not change the fact they've had an adverse effect on a parameter of competition, the MSC. So the position of the claimant's witnesses was, it's sufficient that the MIF results in a higher price, and it's irrelevant that competition is no less intense in the factual than in the counterfactual. It was an error of law that was underpinning their analysis, because that's the very error that the CJEU corrects at 195. And those facts led Mr. Justice Phillips to the conclusion that the counterfactual also sets a flaw under the MSC. And he makes that conclusion under a heading in his judgment that has that title, and it's at paragraph 156. So your Lordships can see that what Mr. Justice Phillips has done here, absolutely correctly as the judge trying this case, is to identify the legal principles set out in MasterCard. Does the MIF have an effect of restricting competition in this market, competition between acquirers for the business of merchants, by comparison with the agreed counterfactual settlement at par? He has analysed it as a matter of fact and economics, and he has concluded that that effect is not present. And that is because he has made a different assessment of the facts and of the economics of this situation, and that he was fully entitled to do. And I don't understand it to be disagreed by the Commission that that is so. Where the Commission disagrees is they say the facts are the same. But, my lords, the facts are not the same. The Court of Appeal's response to this is at paragraph 133 of its judgment, on which both Mr. Turner and Mr. Brealey heavily relied. That's Core Volume 2, 5237. Now that, with respect, is wholly inadequate. If we just quickly turn it up. All they say is the Commission's conclusion was broadly the same as that agreed between Popplewell and Mr. Justice Phillips, namely, in the counterfactual, issuers and acquirers would ultimately not agree bilateral interchange fees. Now, with great respect, the Court of Appeal have missed the points I've just been making to your Lordships. Whether they would ultimately agree is not the point. The question is about competitive process. And so, at 146, another error by the Court of Appeal, because the factual premises that they say are the same are not in fact the same. At 156, the Court of Appeal says the CJU endorsed the counterfactual as a matter of law, and my Lord Reid suggested that meant it endorsed the analysis of the counterfactual as a matter of law. In my submission, that's not what the CJU was doing at 195. It was saying, in a situation where the factual assessment of the counterfactual has not been and cannot be challenged as a matter of law on this appeal, the conclusion that a restriction by effect has been established cannot be challenged. The CJU is not endorsing as a matter of law for all future cases the conclusions of the Commission in this case that the counterfactual does not place a floor under the price. It couldn't, because that's a question of fact. Mr. Turner sought to obscure these critical points by treating this situation as if it were in some way akin to an object infringement. He referred barely at all in his submissions to the counterfactual. He proceeded constantly by talking about how the MIF loads costs onto one side, it's a collective act to raise costs, without comparing that critically, as you have to at every stage, with the counterfactual. And he sought to endorse that approach by relying on some paragraphs from the Advocate General, in which the Advocate General said that you could treat it as obvious in a situation like this. Now, that's the submission the Commission made in MasterCard, and the CJU rejected it. And your Lordships will recall we looked at that. It's paragraphs 183 and 187 of the CJU's judgment, where that argument that Mr. Turner made before your Lordships was rejected by the CJEU. Finally, you can see the fallacy in the respondent's approach from the analogy used by Mr. Turner himself. He considered the example of a steel manufacturer's cartel in which the manufacturers agree on the surcharge for a particular alloy, and he said that's restriction of competition. So he says they've agreed a surcharge on a particular part of the price. I agree that's a restriction of competition because in the counterfactual there'd be no agreement between the manufacturers at all. They would each individually be agreeing with their customers the whole of the price, independently and autonomously. But the outcome would be different if, as a matter of fact, it was shown in that case that for some reason it was necessary for all the steel manufacturers to purchase iron ore together from a single source at a common price. And if that were so, then there would be no restriction of competition depending on the level of that price. Mr. Turner's position is that if that were the fact, then all of the steel manufacturers would have to purchase their steel at zero, because otherwise the incorporation of the price for that iron ore in their agreements with their customers would be a restriction of competition. My Lords, that's what I want to say about the first issue. I just have a few very short submissions on fair share. Would your Lordships be prepared to sit perhaps for 5 minutes now and I can deal with them?
5 minutes.
Or we can start at 2 o'clock.
We can sit for 5 minutes.
I'm very grateful. So fair share, if we go to the guidelines, that's Authorities Bundle 3, 1624. The respondents, with respect, have sought to muddy the distinction between the first and second conditions under these provisions. It is not the function of the first condition under 1013 to seek to balance the efficiencies to which an agreement gives rise against its restrictive effect on consumers. That is an exercise undertaken under the second condition. The aim of the first condition is simply to identify whether an agreement gives rise to objective, appreciable economic efficiencies. Does it result in a saving in costs? Does it result in greater innovation and better products? The question of who gets the benefit is dealt with under the second condition. Now, my Lords, you can see this clearly from the discussion under these guidelines. The first condition commences at 1623, paragraph 48, and goes down to 72. And there is no issue there of balancing. What is excluded is simply the increase in the party's own profits caused by the restriction, because that's not an efficiency. It's not an efficiency. But any kind of objective benefit to the market, such as a cost saving, is an efficiency. And you're not interested in balancing at this stage. The balancing comes in under condition 2, which is at 1628, And if we look at paragraph 85, to which much attention has been directed at 1629, that's where we see the statement, the concept of fair share implies that the pass-on of benefits must at least compensate consumers. That's where the language comes from, not the first condition. Compensate consumers for any actual or likely negative impact caused to them.
This is perfectly clear.
It is.
The case law is not quite so clear. That's the problem.
Well, my lord, can I just rapidly make my submissions? Because in my submission, it is perfectly clear. If your lordships are against me on that, it certainly isn't perfectly clear against me. And at that point, I accept this is an issue of pure European law.
Subject to the fact that 85 has a footnote reference to to Constant Grundy.
But, my lord, the reason for that in my submission is simply that the reality is that in many of these cases, the efficiencies are particular benefits to consumers, and therefore the court often considers the first two conditions together. It's as simple as that. And that's actually what's happening at 241 to 247 of MasterCard. The first two conditions are being considered together. Now,
what you say, what they're saying is that if you consider them together, we don't need to get on to two, because you're clearly looking at one as together with two.
Yes.
You can see you're going to fail on
that's
two.
right. Now, my lord, it was said by Mr. Khan, oh well, they couldn't look at two because the lower court hadn't dealt with two. But let me just show you, lordship, what the complaint was. So we just go back to the MasterCard judgment. And if you go to paragraph 221, I beg your pardon, 223, page 1077, the complaint is that the General Court didn't explain, this is at the bottom of 223, why the first two conditions could not be satisfied on the basis only of the advantages the MIFs produce for cardholders, or why all the categories of consumers must benefit from the same part of the profit. That's the question that's being addressed. And the answer is given at 247. As regards the appellant's argument, the General Court didn't explain why the first two conditions could not be satisfied on the basis only of the advantages and disadvantages for cardholders. It's sufficient to refer to 240 to 245. So they're clearly addressing and answering that question. What they're not saying is, we're not looking at the second condition at all. Because the complaint was that the second condition hadn't been addressed, and they're saying it didn't need to be addressed because you hadn't met it. And the reason you hadn't met it was that you'd shown no appreciable benefit to the merchants whatsoever. And they are dealing together with those two conditions. Now, in my submission, before I leave the guidance, I just want to make a quick submission on paragraph 43. That doesn't take the matter any further, because the guidance was written before the Commission or the courts had considered at all this type of two-sided market, where the consumers are so closely connected and where the restriction on competition on one side has immediate effects on both sets of consumers. The level at which you place the MIF intimately and to an equal and opposite effect affects cardholders and merchants. And that's the point that the court's making at 241. And that's the reason why it says you've got to consider both in the round, 241 and 242. But it says because it's the merchants who are bearing the burden, they must get some benefit. And if the merchants get some benefit, then you can aggregate the benefit that the cardholders and the merchants both get to see if taken together, they outweigh the burden on the merchants. Now, your lordships have my submission. That makes sense in policy terms because it enables you to have a conclusion that's overall beneficial to consumers and efficient for the economy. One final point, my lords. The submission that Mr. Turner made makes no sense because it means that under the first condition on his interpretation of this judgment, there's an obligation to assess the benefits to cardholders, but those benefits are irrelevant to the decision under 1013. If those benefits are irrelevant to the decision, why do you have to assess them? So, my lords, my final point on that is that we do say that when you read 241 to 247 in context, its meaning is perfectly clear in my favour. One thing that's sure is it definitely isn't perfectly clear against me. So if your lordships don't accept that I'm right that this is a clear point in my submission. There is a duty on the court to refer it to the CJEU. My Lords, those are my submissions in reply, and I'm grateful for your patience.
Thank you very much, Ms. Rose. Well, we'll adjourn till 2 o'clock.